There are few treaties possessing a sufficient number of parties. They reflect customary international law by virtue of wide practices or acceptance. The four Geneva Conventions are an exception to this general rule, as the large number of state parties and wide acceptance of the majority of the principles contained in the conventions lead most scholars of international law to accept them as an expression of customary international law. Additionally, some principles of international humanitarian law have most probably attained the status of jus cogens, universal peremptory norms, and are therefore binding against all states regardless of whether they are parties to the conventions. Grave breaches of the Geneva Conventions are the most likely candidates for jus cogens status among international humanitarian law norms. Customary rules of international law originate through the practice of international relations. From the repeated actions of states emerge rules which are customarily followed. Such a rule is not yet a rule of international law but merely a custom. In the process of establishing customary norms of international law, this is first stage of harmonizing the wills of states. In interrelation relations, there exist many such customs, particularly in diplomacy and sea navigation. For instance, a newly appointed ambassador is met in the host country by a representative of the Ministry of Foreign Affairs. This rule is not legally binding but is invariably followed by states. An international custom may remain just that and not become a rule of international law. But if the process of establishing a customary rule advances, it proceeds to the second stage of the concordance of the wills of the states, namely the agreement on the recognition of the custom as legally binding. As a rule, the process of customs transformation into customary norms of international law has two aspects. On the one hand, there is a growing recognition of the legally binding charter of the customs, opinio juris, and on the other, an increasing number of states consider this custom as a rule of international law. An example is the emergence of a basic customary norm of modern international law, the principles of the sovereign equality of states. The custom of respecting the sovereignty of other states had been in existence for thousands of years before it was transformed into rules of international law. Each state exercised supreme authority over its territory, and other states were forced to reckon with this. This practice became a rule of international law only as feudalism began its transition to capitalism. Thus, like treaties, customary rules of international law are established in two stages. The first involves the concordance of the wills of states relative to rules of conduct or customs. The second, concordance of the wills of states relative to the recognition of customs as rules of international law. International practice shows that the overwhelming majority of the states support this conception. Definition of custom. Customs within contemporary legal system, particularly in the developed world, is relatively cumbersome and unimportant and often of only nostalgic value. In international law, on the other hand, it is a dynamic source of law in the light of the nature of the international system and its lack of centralized government organs. There are disagreements as to the value of customary system in international law. Some writers deny that custom can be significant today as a source of law, noting that it is too clumsy and slow moving to accommodate the evolution of international law anymore. While others declare that it is a dynamic process of law and more important than treaties since it is of universal application. Another view recognizes that custom is a value since it is activated by spontaneous behavior and thus mirrors the customary concerns of society. However, since international law now has to contend with a massive increase in the pace and variety of state activities as well as to come to terms with many different cultural and political traditions, the role of custom is perceived to be much diminished. Essential of custom. It is understandable why the first requirement is mentioned, since the customary law is founded upon the performance of the state activities and the convergence of practices. In other words, what states actually do. It is the psychological factor, onion juris, that needs some explanation. If one left the definition of custom as a state practice, then one would be faced with the problem of how to separate international law from principles of morality or usages. This is because states do not restrict their behavior to what is legally required. They may pursue a line of conduct purely through a feeling of goodwill and in the hope of reciprocal benefits. States do not have to allow tourists in or lunch satellites. There is no law imposing upon them the strict duty to distribute economic aid to developing nations. The bare fact that such things are done doesn't mean that they have to be done. Accordingly, the second settlement in the definition of custom has been elaborated. This is the psychological factor, the belief by a state that behaved in a certain way that it was under a legal obligation to act that way. It is known in legal terminology as opinio juris sive necessitatis and was first formulated by the French writer Francois Jenny as an attempt to differentiate legal custom from mere social usage. Bilateral versus multilateral customary international law. The recognition of different customary laws can range from simple bilateral recognition of customary laws to worldwide multilateral recognition. Regional customs can become customary international law in their respective regions, but do not become customary international law for nations outside the region. The existence of bilateral customary law was recognized by the International Court of Justice in the right of passage over Indian territory case between Portugal and India, in which the court found no reason why long continued practice between the two states accepted by them as regulating the relations should not be from the basis of mutual rights and obligations between the two states. Other customary international laws. Other examples accepted or claimed as customary international law include the principles of non-refoulement and immunity of visiting foreign heads of states. United Nations Security Council in 1993 adopted Geneva Conventions as customary international law because since the time being it has transformed itself into customary international law. If any treaty or law have been called as customary international law, then parties which has not ratified treaty will be bound to observe its provisions in good faith. In December 1995, the 26th International Conference of the Red Cross and the Red Crescent, while endorsing recommendation 2 of the Intergovernmental Group of Experts, officially mandated the ICRC to prepare a report on customary rules of international humanitarian law application in the international and non-international armed conflicts. After extensive research and widespread consultation with experts, the report, now referred to as the Study on Customary International Humanitarian Law, has been published in 2005. The purpose of the study on customary international humanitarian law was to overcome some of the problems related to the application of international humanitarian treaty law. The treaty law is now well developed enabling it to cover many aspects of warfare, affording protection to a range of persons during wartime and limiting permissible means and methods of warfare. There are two serious impediments to the application of these treaties in current armed conflicts. First, treaties apply only to the states that have ratified them. Different treaties of international humanitarian law apply in different armed conflicts depending on which treaties the states involved have ratified. Secondly, humanitarian treaty law doesn't regulate in sufficient detail a large proportion of today's armed conflicts, that is, non-international armed conflicts. These conflicts are subject to far fewer treaty rules than are the international armed conflicts. Only a limited number of treaties apply to non-international armed conflicts. They are, to name a few, the Convention on Certain Conventional Weapons, the Statutes of the International Criminal Court, the Ottawa Convention on Prohibition of Anti-Personnel Mines, the Chemical Weapons Convention, the Hague Convention for the Protection of Cultural Property and its second protocol, and additional protocol number 2 of 1977 and Article 3 common to the 4 Geneva Conventions. The Statute of International Court of Justice describes customary international law as a general practice accepted as law. The existence of a rule of customary international law depends on the presence of law elements. Number 1, state practices, uses, and number 2, a belief that such practice is required, prohibited or allowed, depending on the nature of the rule as a matter of law, opinion, juris sive necessities. Most of the provisions of the 4 Geneva Conventions, including Common Article 3, are considered to be a part of customary international law. The Geneva Conventions, having 192 parties now, are binding on almost all states as a matter of treaty law. The most significant contribution of law towards regulating internal armed conflicts is that it goes beyond the provisions of Additional Protocol 2. It is indeed quite clear that the practice has created a substantial number of customary rules that are more detailed than the often rudimentary provisions present in Additional Protocol number 2. It has really filled important gaps in the regulation of internal conflicts. The gap in the regulation of the conduct of hostilities in Additional Protocol number 2 have largely been filled through state practice. This led to the creation of the rules parallel to those in Additional Protocol number 1 but applicable as customary law applicable to non-international armed conflicts. This practice covers the basic principles on the conduct of hostilities and includes rules on specifically protected persons and objects, including specific methods of warfare. In conclusion, we can say that customary international law is the important source of law. An example of a principle of customary international law which was established by both state practice and opinio juris is the principle of distinction, which requires the state parties to a conflict to distinguish between combatants and non-combatants and between civilian objects and legitimate military objectives. This principle is also contained in additional protocols.